Your Honor, what happened here was reprehensible. I mean, the evidence was overwhelming that there was a recount that was rigged here. What's more troubling, it wasn't any more troubling, or more sad in this case, is again, from the state's perspective, that these defendants have never come clean, have never admitted what's been going on. Now, Ms. Dreamer and Ms. May referred to conversations that we had. Just for the record, once again, when I got in this case, one of the first things that I did besides reading the memorandum from Reno outlining this case, virtually met with these ladies. I will represent to this court that they never said anything about any precincts being swapped out, anything being compared for purposes of substituting precincts for those that balance with the poll books or with the official count. In fact, Ms. Dreamer was visibly upset that even someone would even make such an allegation. So we continued on. We presented this case to a grand jury because at that particular time, it became apparent that there was at least some inconsistencies, or at least some people that weren't becoming truthful or coming clean in this investigation. We spent two and a half days in grand jury. 15 witnesses in grand jury. They were subpoenaed, they didn't testify. The ink wasn't dry on the indictments on August 30th when the Board of Elections, under the supervision of Chairman Bob Bennett, issues a press release saying we are confident that no employee of the Board of Elections would knowingly or negligently engage in any unlawful conduct regarding the 2004 presidential recount. We as board members unanimously stand by our employees in the face of these allegations. The board then, after Ms. Maiden was later indicted, the board then issues another statement saying the investigation must stop. Then just a couple weeks ago, Bob Bennett happened to be in the Sandusky area speaking to the Republican Party there, and he calls these convictions a travesty of justice. He says that they did nothing wrong. He believes they'll be eventually overturned. Now, when you look at that, what I would say is vigorous and amazing support from a public body of people who were indicted by a grand jury and now convicted by a jury of violations of election law, felony violations. It's amazing. It's astounding. And then you look at what the state believes is not coming clean these people as to what happened and who was involved, and more precisely, who instructed them to partake in this. Let's talk about that. We have two different proffers that you talk to the people about.
Brian, may we approach?
Jack.
May we approach?
Sure.
Objections overruled. Mr. Baxter,
once again, Ms. Dreamer in her proffer states that she was instructed by Ms. Maiden to discard ballots that didn't, or precincts that didn't balance with the poll books. Meanwhile, Ms. Maiden, as she stated here, and in her proffer, saying that she didn't know anything about any, in fact, I'll read it. I am not aware that any precincts were discarded from the random sample because it did not balance with the poll books. I never instructed anyone to discard any precincts or to verify numbers for the poll books. This had never been practiced for the department. I do not believe that Kathy Dreamer or Rosie Greer discarded any precincts. And then Ms. Dreamer also says that she's not aware, either sentencing or whatever, she says that she's not aware that any precincts were discarded or counted when we compared the official count, which was the second triage, if you will, to exclude and substitute and swap out certain precincts. Yet all the evidence, including Jim Santoro, who testified to this court, says that they did that at the direction of the manager and the assistant manager, Kathy Dreamer and Rosie Greer. So, to suggest that these folks, these defendants, have been honest with the prosecution, or at least even consistent with what the overwhelming evidence is just not true. It just hasn't happened in this particular case. They violated a public trust. They were in a public position. They were there, like the Board of Elections, to protect the public, to maintain the integrity of the election process, which is vital to every component of our system in our society. You know, Ms. Dreamer, in a number of her different places, in her sentencing memorandum, page 7, page 10, page 12, page 13, says she didn't know that this was wrong. She didn't know that this was illegal. She had no criminal intent, no knowledge of that this was illegal. Well, geez, we got her on December 13th, the DVD or video that was shown to the jury, where she was evasive, she and Miss May were dishonest, they were hiding the ball, and Cyrus Taylor and Kathleen Wynn and Miss Lovegren, who were questioning about the process. Little did they know, we found out through the others in this case, that they were really in the process at that point in time of writing this recount. Then later, on December 16th, Miss Maiden, at the official recount, when asked by Sarah Taylor, who took the stand and testified here, when asked, are the ballots as they came out of the machine? She says yes. She doesn't go into any of this recount, any of this 3-day process they went through. And in that video, in that DVD, at some point, Miss Dreamer is depicted there. She's present. She's listening to this. Later on, Miss Maiden appears at a couple board meetings. These are public meetings when the cat's out of the bag. When she's at those public meetings, and she says, first of all, we only looked at the total count. We were not looking at who won, who lost. Well, we know that's not true. We heard the evidence. That's how they arrived at whether or not they were just going to discard or swap out certain precincts. And then later, at a subsequent meeting, when Mr. Taylor, the lawyer, Candace Hoke's husband, George Taylor, appeared at the meeting and said, we have information that 3 or 4 precincts, at least 3 precincts, were counted, were pre-counted, were pre-sorted. She then backs up and says, yeah, well, 3 or 4, but that's it. In her proffer, she says the same thing, 3 or 4, but no more. That was it. Well, we know that's not true. We know that all 34 precincts were counted. So, I mean, I think the court in the state is in a predicament. I mean, this is a sad case of these ladies, these defendants, having an opportunity after opportunity after opportunity after opportunity to simply tell the truth. Not only for the system, but also for themselves. And they have refused to do so. I mean, it's abundantly clear. So the question comes down to, you know, and one of the criteria that Mr. Synenberg cites in his sentencing memorandum, which is, of course, in the law, is that they're in a public position. They're holding a position of public trust. And not only did they violate that, reprehensibly so, but then they covered it up. And they concealed it. And I believe here in another state, I should say the state speculate at this point. Also, Mr. Synenberg indicates that under 29.12b, he identifies 9 factors in his sentencing memorandum, of which he maintains that none apply. We disagree. 3 says the offender held a public office or position, trust in the community, and the offense related to that office or position. Clearly that applies here. Clearly that applies to Mr. Taylor as well as Ms. Maynard. Number 4, the offender's occupation, elected office, or profession obliged the offender to prevent the offense or bring others committed to justice. Certainly, the manager, election coordinator, these defendants were obliged to maintain the integrity of the process of the election. They had a duty to maintain the laws incumbent upon them by the revised codes of the Secretary of State. That applies. And number 5, the offender's professional reputation, elected office, or professional use to facilitate the offense was likely to take future conduct, and it certainly was used to facilitate the offense. They couldn't have done it unless they held these positions of trust, these public positions of trust. Also, the fact, we talked about no restitution. What about the $14,360 to get right there? They get a phony recount. They're out the money. I mean, restitution should be made somewhere along in this case. I don't know if it's apparent here. I'll leave that up to the court, but I think that's a point that sometimes defense counsel misses or doesn't elaborate. So, for those reasons, Your Honor, again, at first glance, you look at these ladies, you look at these defendants, community sanctions certainly seems to be something that's appropriate, but when I go through this process, what happened? And after the fact, it just seems tough to put them on community sanctions. It seems like if they're not honest now, how are they going to be honest during community sanctions? Something this court has to monitor. Is this how we want to start out? Being on probation? So for all those reasons, Your Honor, I don't think community sanctions is appropriate. Certainly leave them for the court to get a sentence. I don't have any magic sentence in this. This is a very difficult situation not only for the court, because I know you have to make a difficult decision. I certainly don't envy you in that position, but it's also difficult for the state. I mean, it's not something that the state will ever want to pursue through to this point, but it comes a time when, in the face of what seems to be an obvious subterfuge or obvious concealment, there's no choice. So thank you.
All right, Mr. Synenberg, do you want to respond?
I do. Judge, how many times a day do you see somebody who doesn't cooperate? If that's what they're suggesting is the reason for incarceration. I would suggest probably every day, all day, day in and day out. You see people who make that choice not to cooperate. Believe me, if Kathy Dreamer could give someone to them to get her job and her life back, she would in a heartbeat. She has no allegiance to anyone but her family, and losing a job that was paying her $40,000 a year and giving her medical coverage is a reason, but would have been reason enough for her to provide information to the prosecutor if it existed. But we're getting far afield when we start throwing around words like reprehensible and rigging, which implies intentional conduct, which they were not convicted of. Or talk about, it's amazing what Bob Bennett might have said. It has no room in this courtroom for that kind of discussion. The truth of the matter is, she didn't know, and the jury spoke when they said that she didn't act willfully and they found her not guilty. That corroborates her stance that she did not know that she was violating the law, Judge. And it's our position that when you look at the 9 factors that are set forth in 29.13b1, that the fact that she held a public office or position of trust is not appropriate because she did not willfully and maliciously use her position at the Board of Elections. Rather, she followed a long-term practice. But let's, for purposes of what we're here for today, Judge, assume that the only factor that the state has offered in support of a term of incarceration, that she did work at the Board of Elections in a position of trust, was applicable. So let's, for the purposes of argument, we'll concede that, and then move on to what the court is required to do next, and that's to determine whether or not Mrs. Dreamer is amenable to community control sanctions. And we would suggest that every factor at that point in time as to whether or not she's more likely or this crime is more serious or whether or not she is likely to be a recidivist weighs in her favor. So if you work through these factors and assuming, as I have, conceding that she was in a position of public trust, and then you move to the next steps as you must with respect to recidivism and with respect to more likely or more serious, every factor weighs in her favor for community control sanctions. So I would ask you, Judge, to make your decision based upon what those factors are that are set forth in 2929. Disregard the adjectives that have been used here today with respect to amazing and with respect to rigging and with respect to her lack of cooperation and with respect to what any member of the Board of Elections might have said in providing their own opinion into the public place, and ask you to provide a period of community control sanctions to Mrs. Dreamer. It will satisfy the requirements of 292911 and will also send out a long message and a harsh message to anybody in the public who thinks that the election system has in any way tolerated